What's up, everybody? We're going to be talking all about trademarks and the cannabis industry today on a webinar that we have called Cannabis Trademarks 101. Joining us will be Sahil from Juristy Law. Let's get into it, and you're going to learn a lot. So stick around, thumbs up, like, subscribe, share this. Hey, Sahil, thank you for joining us. Why don't you introduce yourself?
Hey everyone, as mentioned, my name is Sahil Malhotra and I'm an intellectual property attorney at Juristy Law. I want to thank Tom and Collateral Ways for giving me the opportunity to speak to people in the cannabis industry. Now, we're here to talk about trademarks in the cannabis industry. I'm going to start off with the basics of trademark law, a review of trademark process, the legal standards that are applied during the application process, and what to expect when you go through the trademark process.
If you guys are out there and you want us to work with you, you can head over to Collateral Base and just fill out this page that we have regarding outside general counsel. There'll be a follow-up email on it, and then you can sit down with us on it. You'll get both of us for the price of one. You ready to take it away?
Yeah, let's go. All right, guys, the basics of trademark. Trademark must be distinctive in source, which usually pretty much means it enables the consumer to distinguish their goods and services from another. What does that really mean? I mean, I can tell what an Apple product looks like, and I know what a Microsoft product looks like. And if you can do that, that means your logo, your branding is distinctive or source. Then we come into use in commerce. That mark that you're applying for must be used in commerce. The use should be either in use, or it can be an intent to use. The use must be in a sale across commerce channels. The use also must be lawful. We'll talk about that more later. And also, the mark shouldn't be functional. This usually applies to trademarks in trade dress protection, which usually includes things like product packaging, product design. Think about cannabis packaging. Think about the boxes or packages that you get your cannabis products in, or even your CBD bottles. For your topicals or decor for store layouts or building design. Bird's eye view. We want to talk about the key terms that you'll probably need to be aware of when you're applying for a trademark. You need to know what an examining attorney is. Examining attorney is the attorney usually put on your application by the USPTO whenever you apply for a trademark. They're the ones you're going to have full contact with throughout your trademark journey. Office actions. You are more than likely to get one of these, maybe even multiple, because you are in the cannabis industry and because it is federally still illegal. There's a lot of federal rules that still apply to what kind of mark can or cannot be registered when it's in the cannabis industry. Some of the legal standards that we'll touch on are the Controlled Substances Act, the Food, Drug, and Cosmetics Act. Timeline for a trademark application usually takes anywhere between 10 months to 3 years. I think the backlog right now for the USPTO is listed at around about 8 to 9 months, but I'm pretty sure it's a little bit longer. So let's say you apply for a trademark application today, you're not going to see someone review your application until 10 months from now.
So does that mean like I can apply right now and then put the little R with the circle or the TM next to whatever?
The TM you can't really put until after. That's the one you get to use after registration. So you cannot use the TM until after registration.
So then if I have to wait this long, what are some of the benefits of the trademark?
It's always good to be on the register than to be off the register, because that still allows you to put your priority of date. Whenever you'll have an issue with a conflicting mark, or let's say somebody's trying to oppose your mark, more often than not, they'll look at the priority, and the priority is the date of first use. And the date of first use can be established in your trademark application, which can give you priority over another brand that might think that they're infringing, they're infringing, or you're infringing on their right. Some of the most common mistakes, usually in a trademark application are anywhere between wrong or inadequate class protection, spelling mistakes, incorrect specimen, and that applies to, your website. If you're a website, you need to put up your website. If you're going to be selling, pre-rolls that are CBD pre-rolls only, you're going to have to put up a specimen, meaning a sale of receipt that can show that you've sold these CBD pre-rolls. And also we're going to talk more about the unlawful use of commerce later. Now let's talk about a little bit of the benefits of trademark registration. The basic benefits of trademark registration are the presumption of ownership. It's easier to settle name disputes. The ability that it provides for you to build some level of customer loyalty. It creates a tangible asset that can be licensed, transferred, or signed. That's really important these days because you'll see brands like Tyson 2.0, you'll see brands like Cookies, who are signing licensing deals with a lot of national with a lot of statewide distributors, which is allowing them to expand their brand's reach. I don't know, Tom, if you saw that Tyson 2.0 now is in the DC area.
No, I have not.
The basic benefits are like you're going to be able to protect yourself against competitors. Like the days of being able to like name your brand whatever and maybe make a parody of like something that already exists are kind of over, because if you notice, companies like Mars Wrigley are kind of going after Skittles. Clint Eastwood recently won a lawsuit, $2 million for a CBD product that was using its name. What the trademark registration provides is for the ability to like protect yourself against those situations, because anytime you go through a trademark registration process, you're going to do a search and clearance before you apply for that trademark. And that'll allow you to see if you're going to be infringing on anybody else's brand that already exists. And, it kind of guarantees customer loyalty if you can build like a reputation with that branding. Like I said, you get to use that cool little federal trademark symbol if you get through registration. The ability to go to federal court, and federal court means big damages if you're able to ever prove that. Lawful use in commerce. We talk about lawful use in commerce. The Lanham Act states the word commerce means all commerce which may be lawfully regulated by Congress. As we all know, cannabis is still federally illegal, and the U.S. PTO policy currently is to refuse any application whose goods and services violate federal law, more specifically the Controlled Substances Act. What does lawfully use in commerce really mean? Truly, it's changed and evolved because the federal enforcement against cannabis has lessened and decreased exponentially over the last decade. With an increasing number of states providing legal use of cannabis, the patchwork of state and federal regulations provided unique opportunities for cannabis-related businesses. Now, you can even look in state trademark application process, which will at least be able to afford you state-level protection for your branding. We're going to talk a little bit more about the Controlled Substances Act as we move forward, but I want you to be aware of the CSA and the FDCA, which kind of exist and are usually applied during that trademark application process. More specifically, the CSA. Brief overview: all manufacturing, distribution, and possession with an intent to manufacture and distribute of Schedule I controlled substance is illegal. We know that. And any drug paraphernalia related to a Controlled I substance is illegal. Does this mean legal cannabis and hemp companies cannot have registered trademarks? Not really. Cannabis businesses are allowed to have some level of trademark protection. We just have to be transparent through the application process what goods or products or services that we are registering. The most common Controlled Substances Act refusals during a trademark application process are when the goods and services description or evidence indicates that the registered goods or services violate the CSA. When the Farm Bill passed in 2018, the bill defined cannabis, the bill defined hemp as a cannabis sativa, and anything that contains less than 0.3% concentration of THC.
They changed it. So I guess it's the first exception to, it's finally an exception to the controlled substance ban. It looks like it was a pretty clear ban against, and you have it on your slide, the next one, common refusals.
So that kind of means like any cannabis plant and product containing more than 0.3 THC, more than 0.3% THC that falls outside the scope of the bill and subject to CSA. So if your trademark application for a CBD or hemp product is still likely to receive that initial refusal, but it's more like an opportunity for you to amend your description if it does not contain the legal chemical definition of hemp. So you have to provide the legal chemical definition of hemp as outlined in the hemp bill. More than likely, the USPTO will also request for additional information regarding your product, so you're not making any health claims regarding it. And more likely, you're also going to receive what's called an FDCA refusal. And the FDCA authorizes the FDA to approve new drugs, certain medical devices, food and color additives, inspect establishments where food, drugs, devices, cosmetics are produced and held. So due to this regulation, all CBD brands come under scrutiny during the USP2 application process. A good rule of thumb usually is in the body, not good, on the body, good. I say that because as it stands, the FDA does not allow hemp CBD in edibles or products that claim to have medicinal or therapeutic properties. The common refusals for CBD or hemp applications usually are whenever the evidence or description of the goods indicate that the hemp CBD is edible or has medicinal properties. So you can't have like a tonic that claims, I'm going to cure your sleep apnea, or, I'm going to cure Alzheimer's. You can't say those things. So that's why more often than not, you see things like soothing, a calming effect, will make you feel more relaxed. It won't necessarily say anything like I'll cure cancer. Common ways to overcome an FDC approval refusal is the goods need to be topical, non-medicinal, and non-therapeutic. You need to provide the legal chemical definition of hemp in the description. I want to kind of point out some of these, like examples of trademark applications trademarks that already exist, brands that already exist, like dog walkers, a product that exists in the Illinois market at least, and I think it just made it to DC area and Virginia as well, actually. It
says August 12th, 2020. So
Yeah.
Everybody was worried about coronavirus. Green Thumb Industries was getting a trademark on their dog walkers brand for hemp. It says pre-rolled cigarettes containing industrial hemp.
So you can see that class 34, pre-rolled cigarettes containing industrial hemp, and they have the exact definition as we mentioned earlier, where they're claiming it's less than, the THC concentration is not more than 0.3%. First use, date of application, it's a live application. It's been sitting there since 2020, but they have some level of protection with that. Now you look at Cresco Labs, you see all the different classes they register themselves for. Class 41, they probably have a blog which mentions nothing about their actual sale of cannabis products. That's why it says educational services, namely providing lectures and seminars in the field of cannabis. Applied for in 2019 and registered in June 2020. The last example I kind of want to show are the dispensaries that exist already in the Illinois market. Sunnyside and New Era. Sunnyside has a registration also for a blog, I'm pretty sure. In this scenario, they have registration for t-shirts, hoodies, hats. I'm pretty sure they also have a registration for glass bottles. New Era as well. They're kind of going in talking about their topical products. So they probably have some CBD-based topical products that they sell, and they're clearly claiming that it doesn't have more than 0.3% of THC, and it doesn't have any medicinal properties. And they're able to get these registrations because they're not claiming any medicinal properties. Common classes that are used in the cannabis or CBD-based applications are a class 3, which is cosmetic goods. That's where you'll see a lot of the topicals, creams, lotions. Class 5, you'll see a lot for supplements. As we know, you see a lot of like topicals, tinctures that are sold. Beverages, we see, I'm seeing CBD soda now. I'm seeing CBD sparkling water, CBD coffee, CBD cold brew. 35 for retail store, 42 as for research purposes if you want to register yourself in that, if you're in that industry. And last one for medical and therapeutic services. Maybe you have a massage parlor, maybe you're an actual therapist who uses CBD products in their therapy sessions. These are classes that you can kind of create that brand recognition in. The main takeaways I kind of want to get at, we want everybody to have from this, the goods and services description are kind of make or break your application. You can't lie, do not lie. USP2 has Google too. If you say something and you show a label placed on a CBD product where it claims certain medicinal properties, but in your application you say it does not have any medicinal properties, they'll find that. And then you'll get a refusal, and you won't be able to overcome that refusal until you fix that, or maybe the USP2 won't even move forward with your application. Ancillary goods and services, like I said, your friends, as you saw, places like Sunnyside, places like New Era, even dog walkers. I don't know how many people are utilizing their CBD pre-rolls, but they have registration for CBD pre-rolls. What this allows people to do is, just by being registered in the ancillary goods, you're able to enforce your branding against anybody who might be infringing on your branding. Even if they try to claim that, hey, these guys sell cannabis products, but we're not talking about the cannabis products. You're infringing on a mark that is put on non-cannabis products that can be cannabis products that can be registered.
Yeah, and my question on that was going to be, can you do can you stack them? So can you have like 35, 44, 34?
Absolutely.
And I was looking back, and it kind of looks like they are here.
Yeah.
You see Sunnyside, and you see 3, 22, 41. Is that what these codes are up there? These goods and services codes?
That's exactly what those are. Those are the classes you're going to register in. A basic trademark application process, it's $250 per class or $350 per class. The main difference is, this is the USPTO filing fees. Main difference usually is that in $250 per class, USPTO kind of already has a pre-prepared template that you just fill in the blanks. It works for most people. Or you do the $350 per class application where you custom write the description of your goods and services. And you make that decision from the beginning. How many classes do you want to register in the beginning? You can start with just one and eventually file new applications for the other classes you want to go into. But more often than not, if companies already have certain products that they're going to sell under those brandings, they're going to start registering those. The Sunnyside, I actually, I think a few weeks ago, when I was in Chicago, I saw Sunnyside is now selling more than just bottles. They're selling all these kind of like little trinkets and accoutrements that might be decor, might be koozies, anything that they can put their branding on. It's not necessarily about even about the product at that point anymore. It's more about just getting that name recognition out there. It's to establish yourself as kind of like a brand in that market. And that's what Sunnyside is kind of doing. They're kind of trying to just aggressively just put their name and logo out there so people see it, and people just, as soon as they come to Chicago, it resonates with them that, hey, Sunnyside is like one of the major dispensaries here.
Awesome. Let's sum up some stuff, and then we'll talk about some more things. All right. Well, hey, again, thank you so much for joining us, everybody. Consider becoming a member of the channel, and then, of course, tune in to more episodes of Cannabis Legalization News. And if you have any questions about what next month's webinar should be, leave it in the comments, because we're always looking to do one webinar a month that's relevant to entrepreneurs in the cannabis industry. So we'll see you next time. Bye. All right. Brown chicken brown cow.